May it please the Court. Julie Rodriguez of Greenberg-Traurig, here on behalf of the appellant. We are here challenging a mandatory injunction.
Did you want any rebuttal time?
I'm going to reserve 5 minutes, thank you, for the reminder. We are here challenging a mandatory injunction that requires the trustee, U.S. Bank National Association, to disperse funds from a account that has been set up pursuant to a master trust indenture. Now, bear with me one moment, please.
Isn't this essentially an automatic process that once the draws are approved by the district engineer, boom, they have to be paid?
Absent a default, sure. But
absent what?
A default, sure, I would agree with you. If you looked only...
Why doesn't 4.3 control the situation?
Because 4.3 speaks to when everything is fine. You go ahead and you get a request from the district for a construction draw request, and you pay it up. That's it. It's approved by the engineer, and you don't have to question that. But what we have here, we can't just simply look at that provision in isolation. We have a host of sections that come into play. So, looking specifically to sections 6, Article 6 and Article 8, what we see is that we have certain powers and duties as the trustee that we have to enforce, primarily to the bondholders. Now, this gets interesting, of course, because we have a new bondholder in place, which has told us to go ahead and pay. We still have a prior bondholder whose position from the beginning was, no, there's a default, you cannot continue to pay. Now, the problem ensues because they are looking strictly at 4.3, as the trial court did. From our perspective, understand, we come into this situation pursuant to Chapter 190, under the auspices that we are not to spend a dime as a trustee. We're not to incur any charges. But
except for attorney fees. They were being dispersed, right? Were attorney fees being paid? Timely? Us. Yes.
In other words, we were getting reimbursed by the money in the trust.
So what I'm saying is you're claiming there was a default, so the trustee was under no obligation to perform other than paying the attorney fees.
And they're not paying us directly, understand. The way this is set up is we have the funds in place, and when you look at the different sections of the trust indenture, what it provides is, all right, so first and foremost.
I mean, was there a counterclaim for declaratory relief or something?
No, we have not sued them in this action.
But you were sued.
We were sued.
So you were eligible to file a counterclaim.
We're not at that point yet. We have a host of motions to dismiss that are pending.
Okay.
So we're at this early stage of the proceedings where we just got hit with the motion for injunctive relief, and that was granted, and now we're here.
I got you.
Okay. But your question is pointed, and then it leads me to the main analysis of what it is that we are looking at here, which is simply an interpretation of a contract. This is a loan structured as a bond transaction. Okay. The bondholders agreed to finance the loan, and through that mechanism, what the district does is levy assessments to the landowners of the district. Those assessments are then used in turn to pay the trustee. The trustee then uses those funds to pay the bondholders. Well, we're now $18 million in the hole, and that's a problem. So we cannot simply look to 4.3. 4.3 is a scenario where everything is running smoothly. But in this case, the parties did envision that things could go wrong. You have certain sections, like Article 8, that speak to the remedies that you could pursue.
Let me go back to something you said. You said you're $1 million in the hole. And I mean, that $1 million represents the attorney's fees and I think some trustees' fees or something related to that. It's not construction of this project, which is really what this bond money principally was all about. Is that correct?
No.
Well, let me finish my question.
I'm sorry,
I just want to understand if my premise is correct so far, and it doesn't sound like you agree with that, but let me finish my question. Does $1 million in the hole mean there's no money and there's $1 million deficit, or you have $1 million less of the bond proceeds available to move forward than you think you should have?
Two things. The $1 million reference, I think, is separate. We've got two injunctive issues going on, one of which was not appealed. They asked for prohibitory injunctive relief because we were using the monies from the trust to pay for our legal fees when we had to fight them in the bankruptcy proceedings. That's the $1 million figure that you may have seen in the record and throughout the papers. The $18 million figure that I referenced earlier, that is the amount that is due to the bondholders. In other words, the district comes in, makes construction draw requests to do its part for the construction, right? So it's asking us, pursuant to 4.3, to give out the money so it can use it for the construction. But it has to pay that. That's the loan. And the way it pays that is by levying assessments on the landowners in the district. That in turn is given to us. We submit that to the bondholders. So
what's your irreparable harm if this project goes forward and these invoices from contractors are paid?
Here's where we stand and the problems that we see right now. We have, as I said before, no obligation under this agreement, this trust indenture, pursuant to Chapter 190, to incur any expenses in this deal, right? That's in various provisions of the trust. Now, I start with that proposition because it's important looking ahead to what may happen here. We have initial bondholders who told us there's a default. They gave us the go to disperse some of the funds when the initial default happened back in May of 2010. But after the litigation was started, we couldn't do that upon the default. We could not act without direction and, from our perspective, indemnification. Why? Because we're looking at this from the perspective of we are acting for the benefit of the bondholders, right? There are various bondholders involved, the most recent of which gained ownership of two of the series of bonds after the litigation commenced. We cannot, this is not our money, we certainly have a security interest in this money, which then ties into the $1 million that you referenced and future fees. But we cannot, under this agreement, simply say, okay, I'm going to ignore the $18 million, I'm going to ignore the default, I'll give you the proceeds under 4.3. Let's forget about everything else, because you got a confirmation order from the bankruptcy court. It didn't adjudicate your default, but I can just close my eyes to that. I can't. I can't, because I have a duty to the bondholders, and I have to look after myself as well as a trustee, because I can be held liable for willful misconduct, gross negligence, and the next bondholder that comes along could say, what were you thinking? You have $18 million that are owed, and you continue to give out money. How? When you have an event of default. So part of what the trust indenture tells us to do and allows us to do is exercise our judgment. What would a prudent person do? And that's literally how it phrases it. The ultimate position we took here, and it's at the hearings,
So if we deny this appeal, what other remedy do you have?
We'll have to look at what it is that we can do going forward under Article 8 to see what counterclaims we could bring. But our main concern is that somebody looking at this later on could say, you didn't do enough to protect the bondholders, certainly not the interests of the
Well, if you get a court order requiring you to make payment, doesn't that get you off the hook as to that argument?
It may or may not, Judge. I don't know what's going to happen with, I've got ITG sitting in as the initial bondholder.
Your main argument is these defaults that you're contending, they were never fleshed out prior to the entry of the preliminary injunction. You never had an opportunity to prove anything?
And forgive me if you could...
Did you have an opportunity to prove there were defaults, and that's why payments weren't made on the construction draws?
Right. We're at such a preliminary stage that nothing is
you never had an opportunity. Is that what you're saying?
Exactly. We haven't had an opportunity to get into the merits of this case. The only thing that's, please tell me if I'm not answering your question, as I understand what you're raising, is what's been determined by the trial court at this point is just, look, I'm looking at section 4.3, they've requested funds, go ahead and pay, they've got the confirmation order from
And the
bankruptcy
trial
court.
judge looked at it as a perfunctory situation.
Exactly.
And I'm trying to find out if I'm the trial judge and you tell me what you're telling me on appeal, why wouldn't I give you a chance to prove up your defense to payment?
Exactly.
Did you argue that to the trial judge below? Saying it's not perfunctory, judge, because here's the other provision that requires us to do these inspections and to verify things are being done.
Most certainly we did.
And the judge said, doesn't matter. It's just a money thing.
Yes, if you look at the order granting the mandatory injunction, the statement there is simply look to 4.3. If you look at some of the statements made by the judge at the hearing, it was that the way that 4.3 is phrased supersedes anything else that might be happening. And she really did look to the confirmation order to, I suppose, salvage the situation for the district, but it doesn't. I mean, we've got, part of what they do here to try to get out from under the default issue is to raise legal impossibility. But that legal doctrine cannot help them here, because what ended up happening in this situation is something that was entirely foreseeable. Either the district goes bankrupt or the folks who are paying the district so that it can make its payment go bankrupt. The provision under Article 8 that we look to is all-encompassing. If for any reason you cannot pay, then you have an event of default. And the cases that construe the legal impossibility doctrine tell us, sure, you can look to an order that prevents you from doing something, and then you're strapped, your hands are strapped behind your back, you can't do anything. But not if it's foreseeable, not if it's a risk that you assume, and that is precisely what was done here. I mean, this indenture speaks to a host of scenarios that can happen.
Well,
and
was
it
the
did
district
happen.
engineer deposed or put under oath or what have you? I mean, why is the district engineer saying, look, pay the money?
And I missed the first part.
The district engineer, what was the district engineer deposed as part of this process?
To my knowledge, Judge, what ended up happening was we had an evidentiary hearing where the district engineer did testify. But understand.
He must have given some, the defaults were addressed through his testimony?
The defaults were addressed through the confirmation order. That's really their argument. That's the backbone of their argument. From the district engineer's perspective, this is a ministerial thing. Once I approve, as a district manager, engineer, forgive me, the construction draws that are requested by the district, under 4.3, trustee, you have no say other than to do it. But the default is smack in the middle of all of this, and it changes the dynamics of what the parties' rights and obligations are, and that just simply wasn't addressed. It was addressed only by virtue of the confirmation order, but we know, because the bankruptcy court is on the record saying so, that it did not decide the issue of the default. So we're back here, and we're telling the trial court that you cannot simply look at 4.3 in a vacuum, because the rest of the indenture speaks to what happens once an event of default takes place. And what happens is that, again, we have, as trustee, have to use our judgment and protect the bondholder's interest. Despite the fact that one of them is now aligned with the district and the developer, saying go ahead and pay. But here's what's interesting about that and very suspect. When we go ahead and we tell the new bondholder, fine, we'll go ahead and give out the funds, give us an indemnification to which we're entitled to under this indenture trust, they refused.
The tough thing about 4.3, though, is it doesn't really give you any wiggle room. It tells you that you shall withdraw from the series acquisition and construction account and pay the person named in the requisition once the engineer is certified that it's appropriate. I mean, it doesn't say, but if these other things are going on, then maybe you shouldn't. I mean, it speaks with authority. It tells you got to do it.
No, I'll grant you that, but it's not the only piece in this indenture, and we can't, in the case law is well established that we simply cannot isolate that one section and say everything is good. We're going to follow that and that alone, because we do have an event of default and there are repercussions, and the parties' rights and obligations change as a result of that, and we can't ignore that.
So anyone that's going to do work on this site pursuant to a contract or an order to do work should not take assurances that they're going to get paid when they've earned the money, because all these other things may cause them to have done all this work and not get their requisition paid.
Yes, and let
That's
me
a pretty
qualify.
scary thing in a project of this magnitude.
No,
I don't know why anybody would undertake to work there.
And let me answer it this way as best I can, all right? There's only so much we can do as a trustee. There are certain obligations that we have. When we get a request for the construction draws, it's a matter of what else is happening in this transaction, not the nitty-gritty of who has the district contracted with as an independent contractor to deal with, X, Y, and Z matters, which is what I believe you're referring to. But from our position, we've got this document supplemented by various other indentures. And within that, we know that we can give out this money, and as you say, we shall. But if there is an event of default, somebody could be looking to us at the end of the day. And
You're
certainly
into 4 minutes, so you're using your rebuttal time, but you can keep going if you'd like to.
Just to finish your question, and then if you have any other questions, obviously I'll answer, otherwise I'll reserve the rest. But, so this is all with the notion that we have to protect the interests of both the bondholders here, and because that changes, the ownership of the bonds changes and has changed periodically throughout
But
the
don't
years.
the bondholder, don't they count on this project being built out and properties being sold and revenue being generated? I mean,
Sure, but they also
so
count on being
protecting
paid.
them I would think would be having this project built and having contractors and engineers and architects and everybody that's going to be doing this, I take comfort in the fact if I do the work, I'm going to get paid. I mean, I don't envy the situation you're in. You're kind of between two competing interests here, but it's a concern.
My last point before I sit down and reserve the rest for rebuttal is keep in mind a couple of things. We came into this, and we are required to be in this position, meaning a corporate trustee has to referee this deal by virtue of Chapter 190. That's what's required, right? Because it could play out as it seems like this case is playing out. All of the interests are being aligned on one side all of a sudden, and we're being left with just saying, guys, I'll give you the money, but give me some indemnification to which I'm entitled, and we're being told no. And under that situation, with $18 million on the line, and more being requested of us, we can in good conscience do this and expose ourselves to the liability that is surely forthcoming.
All right, you've got a little over 2 minutes for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Ricardo Reyes, and I represent Fiddles Creek Development District Number 2. As the panel is probably aware, Fiddles Creek Development District Number 2 is a special purpose government entity created under Chapter 190 Florida statutes, and it's responsible to carry out a legislative mandate of infrastructure construction within the district known as CDD Number 2 in the Fiddles Creek project, roughly 1,000 acres within the district. And that infrastructure construction is necessary in order for the totality of the development to be completed. We believe that you should affirm the court's preliminary injunction. As I will explain, the court was correct in requiring the construction draws to be paid from the construction trust account. Her findings are supported by the terms of the trust indenture and the evidence presented below. Her injunction preserves the status quo that existed between the parties before this dispute arose and will protect the public interest, both in carrying out the legislative mandate and ensuring that development occurs in this project as contemplated by the statute and when the homeowners bought in this community.
Take me through the various parts of the master trust indenture, the Section 4 and that Section 8, as to how they should be read in tandem or separately.
I'd love to, Your Honor. 4.3 has mandatory language, as you have pointed out here today. It says shall. The funds in that account shall only be used for construction. It goes on and says when there is a certified requisition from the engineer, the trustee shall withdraw funds from the account and pay those requisitions. There are no caveats or restrictions or exceptions to that language. It is absolute. The trustee would ask this panel to find somewhere in this indenture that there was an obligation on the district to obtain bondholder indemnity as a condition to fund draw requests. Because that was what was argued to the judge, that they would be happy to fund draw requests. We hear today...
Is that anywhere in the indenture?
What is indenture?
Is that in the agreement anywhere else?
That-
The argument? Where did they get that from?
At the preliminary injunction hearing, the trustee testified that the trustee would fund draw requests if we, the district, obtained indemnities for them from the bondholders. And they cited to Article 6. Article 6 talks about indemnification from the bondholders when the bondholders request the trustee to take action, not when we ask the trustee to take action. And they wanted to read those provisions as requiring us to provide that indemnity. The judge noted that in paragraph 13 of her injunction, that the reason put forth to her why they hadn't paid the draws was a request that we provide indemnities. That is not in the indenture. And so I submit that when the draw requests are submitted, it is a mandatory obligation. It is an automatic obligation, as Justice Black pointed out, and therefore it was proper for a mandatory injunction. The trustee asked for a condition that doesn't exist in the indenture.
And the court was powerless to rewrite the agreement.
Of course, powerless to rewrite the agreement, and that was the reason put forth to the court. So when we hear this discussion of defaults, I think it is a distraction from the issue at hand. It is not the reason given. They said,
Just hypothetically, if there were defaults, evidence should have been provided at the hearing?
yes, except that wasn't, they didn't say, we're not going to fund, there's events of defaults under any circumstance. They said, we fund if you got us bondholder indemnity. It's not our obligation to do, number one. The trustee acts as if it has an economic interest in this matter. This isn't money owed to them. It is money owed to the bondholders. The bondholders have not opposed the payment of the construction draws. There is no record evidence. I heard counsel talk about bondholder positions. That wasn't in the record to the judge below of bondholders supporting and bondholders opposing. They did not testify. And in fact, there was a bondholder sought to intervene, and that wasn't even heard at the injunction hearing. So they did not present to the court bondholder opposition. Moreover, Article 8 has remedies that the bondholders can elect, and there's been no evidence that any remedies have been elected upon an event of default. The bondholder, in fact, they acknowledge, I think it's in a footnote in the reply, that the bondholders have not elected to invoke the remedies upon an event of default. So we have this project that needs to proceed. There is a segregated account that is for construction draws, and the funds are there to be used for construction. And the trustee is holding them up, claiming that all the funds in this trust estate has to be segregated to pay its legal fees as it litigates and defends itself for its conduct, and that nothing can proceed in this project when no defaults, no remedies of default have been invoked. And let me remind the court that this number, this $18 million number, is not money that the district owes. The indenture is very clear that the bonds are not an obligation of the district. Our obligation is to collect assessments, assess the owners. Those assessments are remitted to the trustee. The trustee pays the bondholders. We have been prevented from collecting certain assessments. In the moving papers, we talked about off-roll assessments and we talked about on-roll assessments. When there was a bankruptcy of the developer, there was a stay, obviously, and then the confirmation order established a new payment structure on assessments. So we, as a government entity, are prevented by that order. We are enjoined from violating that order, and that order says there will be a new payment structure on the off-rolls. We can't collect those. On-rolls had to be paid current, and we have been remitting on-rolls. In fact, Ms. Brecker, when I cross-examined her at the hearing, admitted they had collected some $4.2 million in on-rolls, and still we're not paying construction draws. So this isn't money that we owe. It isn't a default in the traditional sense of a contract. It isn't money they're entitled to, and it isn't money that we owe. So it is a unique circumstance, and we really do have a legal impossibility by virtue of the bankruptcy order. And we cited to the court a couple of decisions that I think are very helpful on the context of legal impossibility, because legal impossibility would mean we did not breach the contract. And we cited to the court the Leon County versus Glusenkamp case. It's at page 27 of our answer brief, in which the trustee, by way in the reply, acknowledges that there's not a breach when an order makes performance impracticable. I think they said compliance with court order must affirmatively bar, prohibit, or forbid party from doing what the contract requires. I think those were the trustee's words, acknowledging when legal impossibility would apply. Well, I have an order that says I cannot collect these assessments. The trustee admits, the indenture clearly states, that is the only source of dollars for which I have to pay to the trustee in turn to use to pay the bondholders. And I am prohibited temporarily from collecting those. I continue to collect the on rolls. So this is there is not a default on the part of the district in the traditional contract default sense, and we really have a legal impossibility temporarily based upon the confirmation order. So this argument of default, number one, they agreed to fund if we provided indemnities from the bondholders. It's not our obligation. So Judge Pivacek got it right, the trial court got it right, when she found that 4.3 is automatic. It can be enforced by mandatory injunction because she does not need to supervise its performance once the engineer certifies. And Article 6 is indemnities when bondholders request action, which is not the facts of this case. And no one has elected remedies under Article 8 under this indenture that would change the dynamic here. And that's something the bondholders would do, not the trustee, without their consent. So the court, I believe, properly ruled that we had a clear legal right to the relief sought in granting us this injunction. I want to address, if I could for a moment, with respect to the issue of irreparable harm, inadequate remedy at law, and public interest. The court, again, had ample evidence in the record to make her findings with respect to all three of the other elements for an injunction. Keep in mind, though, with irreparable harm, it could have been presumed in this case. The court found a statutory violation. She found that an injunction is a remedy available to the district under Chapter 190. That's Section 190.041, and she found a statutory violation, and under the case law we cited, irreparable harm could be presumed. There's a case called Harvey versus Wittenberg, 384 Southern 2nd, 940. It's a 3rd District case, 1980, relying on a 2nd District opinion called Times Publishing versus Williams, 222 Southern 2nd, 470, from 1970. Irreparable harm is presumed when there is a violation of a statute designed to protect the public interest. So I pointed out that irreparable harm could have been presumed as another reason to affirm, but there is substantial competent evidence in the record of that irreparable harm. The district engineer testified, the district manager testified about the effect to this district upon a delay in construction. That if the infrastructure construction isn't completed, then, which was referred to sometimes as horizontal construction, the sewers and pipes and sidewalks, etc., roads, that was going to affect the vertical construction. The vertical construction would then be stalled, which would prevent sales, and sales would prevent collecting assessments. And the court found that ripple effect was supported by the record and was an irreparable harm. It is impossible to quantify the exact loss of assessment dollars from that delay in construction. And those are the assessment dollars that we need to collect to in turn remit to pay bonds. So the court had ample evidence in the record. The district engineer testified as to, I believe, 4 specific development projects that had deadlines of preliminary acceptance items from Collier County that needed to be met. He provided the dates, the work to be done, and those deadlines were time sensitive or it would delay construction. This was not controverted below by the trustee. And while the trustee may disagree with the engineer or may not like that evidence, there is substantial competence evidence in the record, and on an abuse of discretion standard, the court's findings of irreparable harm and inadequate remedy at law ought to be affirmed. And then lastly, in protecting the public interest, the trustee really has nothing to say on this point. They say it doesn't protect the public interest to rewrite the contract. We're not asking to rewrite the contract. We're saying 4.3 says what it says. Their condition of providing bondholder indemnity, it's not there when we ask for draw requests to be paid. But the public interest is served by this court's injunction in that the legislative mandate can be carried out, the confirmation order isn't violated, and the residents of the community are protected, and the values of their homes are protected in that the construction proceeds. And so I respectfully request, unless the panel has other questions, that the court ought to be affirmed as the findings of fact in this injunction are adequately supported by the record, and the court did not abuse her discretion in entering this mandatory injunction.
All right, thank you. And you have about 2 minutes left for your rebuttal.
Thank you. Let me go first to the question that you had about indemnification. If you look to sections 6.1, subsection C, subsection...
Yeah, I think I said 8 earlier, but I meant 6.
Right. There are 3 that I can point to immediately here, aside from the overall piece itself, which speaks to this, but so specifically 6.1C4, you also have section 6.3 as well as section 6.7. And what they say is, because we come into this deal as the intermediary to facilitate the transition of these funds, provided that the terms are complied with, then one, we're not to expend any funds of our own. And if we think we are, if we don't get assurances, given the situation, especially what we're in now, that there's a problem down the road, we don't have to act unless we get indemnification. That's our right. When you look at these 3 sections, that's a right that we have. Now, when he says that the counsel says that the bondholders are not taking a position, if you look to the record, the supplemental record that we filed in support of our brief, and this is, I'm looking at page 2984, there is a letter from counsel, Mr. Edward Sheffy, demanding that we comply with the construction draw request. We in turn responded at supplemental appendix 2985, letting him know that the situation is such that we require indemnification, and there was nothing forthcoming. All right, that bondholder moved to intervene but never pursued it. When he was asked by the trial court to set the matter for hearing, he said, let's postpone it. Okay, so they're out of this. In the meantime, and back channeling us, they're telling us to go ahead and pay the construction draws, but at the same time they will not give us indemnification.
You got about a half a minute to wrap up.
So my last point is going back to what's at stake for us as a trustee, keeping in mind that we have a security interest in these funds. It's out of those funds that we will pay our fees, that we have paid the $1 million that you referred to earlier, Judge Morris, and that we will continue to pay. So that's counterbalanced now by the demands that are being made upon us. With a default in place, nothing to say that they're going to succeed on the merits of this based on what we're seeing here and the legal doctrines of what we discussed here today. So we do very much have something at stake here. And exposure down the road for a bondholder, as I mentioned before, who may come across the situation and tell us that we did not act accordingly, according to our duties. I thank you, and I ask that you reverse.
All right.
Thank you.
Thank you. Safe journey back home. Let's revisit that Moriarty.